So is this a U.S. Thing? And the answer to that is a certain amount of uncertainty. It's clearly a much bigger deal in the United States than anywhere else. Let's look at our frequent comparison. Sorry, this is a rather unreadable slide. The color coding came from some research I was trying to do to see if there was a correlation between housing markets and punishment, but I should have replaced it with those hot countries. The red countries have the hotter markets. But don't ignore the color for a moment. The point is that there are things in Europe that approximate the life without parole sentence. The country that has one that's closest and that uses it the most is England and Wales. They have what's called a whole life sentence. In England, if you commit a murder, there's a mandatory life sentence. The judge then sets what's known as a tariff. That's the minimum sentence that you should serve before you can be considered for parole, basically. And that is supposed to reflect retributive and deterrent purposes. After that point, you can be released by order of a essentially parole board. Under European human rights norms, that release agency cannot be a politically accountable one, so it has to have some insulation. In any event, under the law in England, that judge can decide to issue what's called a whole life tariff, and basically say deterrence and retribution are so demanding in this case that nothing short of a whole life sentence will meet them, and therefore there is no point at which you will become eligible for parole. The only other country in Europe that appears to follow that is the Netherlands. And in both cases, you'll notice they have relatively few people in prison under those sentences. So in England, you've got 36 out of 11,000 people serving sentences for murder, theoretical life sentences. In the Netherlands, some 37 people. Now, these are obviously smaller than the United States. Still, we have 41,000 people serving life without parole sentences. So even taking our population into account, kind of a big deal. Other countries in Europe tend to have, it varies. Some, like our former Eastern European, former communist bloc countries, tend to have fairly lengthy minimums, 25 years, 30 years, 26 years. But other countries in Europe don't even have life as a possibility. Spain, 40 years is the longest you can serve, and you'll get parole from that sentence. So it's, your risk is that even if you don't get parole, the most you can serve is 40 years. When we look to Latin America, again, very little use of the life without parole sentence. It's unconstitutional in Mexico and a number of other Latin and, well, in this case, North American countries. Canada has narrowly upheld it in its Supreme Court. And this case, which I just posted on BSpace for you, which is a decision by the European Court of Human Rights considering the English whole life sentence, whole life tariff, does a nice job of summarizing the state of the law around the world on this. So if some of you are interested in writing on this topic, and maybe even on that case, this would be a very good case to read. The issue that was raised in this case, which is called Vintner and others, involved 3 murderers in England, all of whom had been given a whole life tariff. And the question asked in that case was, does this whole life tariff violate Article 3 of the European Convention on Human Rights? We've seen before that that was held not to ban the death penalty. It was actually subsequent treaty additions that made Europe largely death penalty free. But the question had never been decided as to whether a life without parole sentence would violate Article 3. And that provides that article that no one shall be subjected to torture or to inhuman or degrading treatment or punishment. A majority of the chamber and the European Court of Human Rights sits in essentially panels, and so there's an appeal to the whole court, which is called a grand chamber, so we may see yet an appeal in this case, narrowly divided, 5-4. The majority basically concluded that the analysis must begin with whether the sentence is grossly disproportionate. As we'll see, this is similar to questions we asked under the Eighth Amendment as well. And they have said that gross disproportionality should be a very hard standard to meet. And they basically look at this and they go, you murdered somebody, and these are usually aggravated murders. This is not inherently grossly disproportionate. But what the European Court of Human Rights, and that's actually fairly consistent with American jurisprudence, where they really differ from us, is the next step. They say that even if the sentence isn't grossly disproportionate, when it's handed down, at some point, maybe after the guy's been in for 20 or 30 or 40 years, they can come back to court and say, wait a second, maybe it wasn't grossly disproportionate to sentence me to this, but now I've been in prison 30 years. I've been a model prisoner. You fill out the rest. It doesn't serve any purpose holding me in prison. And the European Court of Human Rights has held that and holds again here. When it can be shown that the applicant's continued imprisonment can no longer be justified on any legitimate penological grounds, and that the sentence is irreducible, both de facto and de jure, then it could be that it is a violation of Article 3. And what they held on these actual cases is that because in one case the person had only been in prison 3 years so far, and in the other two, the person had been in prison for over 20 years, but that's less than some tariffs that aren't a whole life tariff. The position was basically it's too early to decide these cases yet. So we should not read this as a decision upholding LWOP in the European community. What the European Court seems to be saying is we don't really think European countries do this to people, and we haven't seen evidence yet that they have. Right? So imagine in America there'd be a lot of evidence because we have a lot of people who have served 30, 40 or more years on model records. Interestingly, the dissent, or I should say the dissent, lays out a very strong view on the Article 3 issue of inhuman or degrading treatment. We conclude there was a procedural infringement by reason of the absence of some mechanism that would remove the hopelessness inherent in a sentence of life imprisonment for which, independently of the circumstances, there is no possibility whatsoever of release while the prisoner is still well enough to have any sort of life outside prison. So while the majority is kind of saying, well, just hold on, maybe the Home Secretary or the Prime Minister will decide to release you, and if they don't in another 10 or 20 years, come back and we'll decide if now it's cruel, unusual, and degrading punishment to hold you. The dissent is basically saying there's a problem with that. While you're waiting to go back to court, you have no hope that there's any reliable mechanism for your release, because under the British law and administrative procedures, they basically don't have any clemency except for what they call compassionate release. Once you're within 6 months of dying, they'll consider releasing you on compassionate grounds. So that's what you might call a procedural argument, that there's no procedure here for considering review of this sentence. All it would take, for instance, under previous English practice, even if you got a whole life term, after 25 years, the Home Minister or Justice Minister would review that and decide whether it was still warranted. Now it's not clear whether that will exist because it's no longer in the statute. And it's the absence of that guarantee of at least some consideration that the dissent finds to be degrading in its absence of hope. The German Federal Constitutional Court back in the 70s went a bit further. In holding that you couldn't justify life without parole sentence, the court, and this is a summary rather than a quote, the court found that the state could not turn the offender into an object of crime prevention to the detriment of his constitutionally protected right to social worth. Respect for human dignity and the rule of law meant the humane enforcement of life imprisonment was possible only when the prisoner was given, quote, a concrete and realistically attainable chance to regain his freedom at some later point in time. Now, that is the question that will be answered at least as to juveniles in these two cases, Miller versus Alabama and Jackson versus Hobbs, now before the U.S. Supreme Court. The precedent for this was established only a couple years ago in the article I discussed a little bit, at least in the article I gave you, Dignity and Risk, the long road from Graham versus Florida to abolition of LWOP. It was originally called Graham versus Sullivan, so my apologies for this slight differentiation in the slide. There, Justice Kennedy had decided 5-4 that it deprives the convict of the in that case, the issue was whether juveniles, people under 18, who had not committed a homicide, but just a very serious crime, and had been given an LWOP sentence, whether that violated the Eighth Amendment's cruel and unusual punishment. And the court there or at least Justice Kennedy for 5 or 6, I'm trying to remember, I think it was only 5 justices, held it deprives the convict of the most basic liberties without giving hope of restoration, except perhaps by executive clemency, the remote possibility of which does not mitigate the punishment. So you see there a similar concern to the dissenters in the European Court of Human Rights that there's no realistic mechanism for release, but the substantive point is this notion of hope. Is there a right to hope? If you tell someone, look, there's no hope that you can ever be released, no matter what you do, and especially if that person's 14 or 18, and you're saying no matter what you do over the rest of your 90, if you live 90 years, you can't do anything that will convince us that we can let you out. You're essentially depriving them of hope. And that's in some ways the question that will have to be answered by the Supreme Court. Is killing somebody, unlike these other serious crimes, a sufficient ground for depriving somebody of that age of all hope? Both of these are very serious cases. I can't go over the facts now. Unlike Dakota Eliason, these are stranger killings of considerable aggravation. I'm going to skip these slides. So the situation that the court is going to have to consider, they're going to have to think about two things, as they always do when they consider Eighth Amendment proportionality. Is this just grossly disproportionate, just like the European Court of Human Rights considered it? And that's kind of a subjective judgment. Does it seem to us to be grossly disproportionate? And the second question is, what about the states? Is there a pattern that suggests that this is a rare or capricious or unusual sentence? Now, in typical non-capital cases, the Supreme Court has asked the question about gross disproportionality first. And if they found that it wasn't grossly disproportionate, they don't go on to ask the second question. And typically, as we saw in Ewing, the three strikes case, they say, well, there's lots of different rationales of punishment. Can we really say that this is grossly disproportionate? One interesting thing about Graham versus Florida or Sullivan is that there the court decided to flip it around and first look at the states and only then consider the disproportionality. If they follow that precedent here, they will see a pattern that may help the petitioners. Only 19 states currently allow LWOP for murders who are 15 or who are younger than 15. But those include some big, non-southern states like California, Illinois, and Pennsylvania, and also Florida. These are some of the biggest ones. Nationwide, there are 2,500 prisoners serving LWOP for a offense committed as a juvenile. But when you actually look at, especially very young offenders, and look at them compared to the number of murders in that age group, these are incredibly rare. I mean, I was a bit shocked to realize that there had been 3,632 murders by people who were under 15 at the time they committed the murder since 1990. But of that number, only 58 have received this very extreme sentence. If the court does decide that, okay, it's unusual, but is it truly disproportionate? They're going to have to ask whether any of the existing major rationales of punishment are meaningfully advanced. Now, we already saw in retribution and in the Roper versus Simmons case that with juveniles, especially someone as young as this, but in Roper it was anyone under 18, the argument was that juveniles lack sufficient cognitive maturity to either be fully responsible for the crime in a retributive sense or calculating enough to be deterred. It's very hard to see how the same arguments won't apply to this case. Now, others actually argue that LWOP won't, in the end, be sufficient retribution. This is defenders of the death penalty, but I want to pass that by for now. The other question will be incapacitation. Many of these crimes were very serious. In one case, a 17-year-old raped a 5-year-old and tossed her from a 14th-story window in Chicago. A 16-year-old bludgeoned an elderly woman, and then from prison nailed a bomb-like device to the judge. Right? So these are cases where there's reason to believe that the person may commit more crimes. And the issue will be whether parole can be trusted in these cases, right? Whether it's sufficient for states to have the parole option, that is to not parole people, and whether incapacitation really requires life without parole. I'm going to kind of come back to this slide because there's too much on it to summarize in the 2 minutes I've left. So hold a final thought as to where dignity and risk suggest this case may go, and I'll try to give you a prediction on its outcome on Tuesday when we're together again, as well as move on definitely to unit number 16. Have a great weekend.